My presentation will deal with international law and EU law in the Constitution of Poland. First, I'll discuss the constitutional basis for international law and then for EU law. And in the third part of my presentation, I'll briefly summarize the most groundbreaking decisions of the Polish Constitutional Tribunal related to collisions between EU law and Polish national law. To begin with, the Polish Constitution of 1997 is regarded as favorable towards international law, and first and foremost, its Article 9 refers to relations between national law and international law. So Article 9 states that Poland abides by international law binding on it. And this provision embraces all sources of international law as contained in Article 38 of the Statute of the International Court of Justice. So it enumerates the following sources: international agreements, international custom, the general principles of international law. And Article 9 imposes on legislative bodies the obligation to create domestic law that's consistent with international law. The next important provision in this context is the provision defining the catalogue of the sources of universally binding law. It states, Article 87, it states that the Constitution, statutes, ratified international agreements, and regulations are the sources of universally binding law. This provision concerns international agreements adopted through ratification. Only those agreements are a source of international only this source of international law is directly mentioned in the Polish Constitution. And the Polish Constitution recognizes only ratified international agreements as a source of universally binding law. Agreements concluded in a manner other than ratification, like by signing, exchanging notes, or accessing, are not a universally binding law. Now I'll discuss the division of international agreements. The Polish Constitution distinguishes 4 types of international agreements, and this division is essential for indicating the rank of a particular kind of agreement within the hierarchy of the sources of law. So firstly, there are agreements delegating to an international organization or an international body powers of state authority organs in certain matters. These agreements are ratified upon consent granted by statute in the exceptional legislative procedure or upon consent granted in a referendum. The exceptional legislative procedure consists in adopting a statute granting consent ratification of an international agreement by the same as the lower house of the Polish parliament, by a qualified majority of 2/3 votes in the presence of at least a half of the statutory number of MPs, and in the same way it's adopted by the Senate. And secondly, there are agreements ratified upon consent granted by statute, adopted in the regular legislative procedure. Article 89 indicates that ratification and withdrawal from an international agreement requires consent granted by statute. And this is the case when the agreement concerns peace alliances, political or military treaties, freedoms, rights or obligations of citizens, Poland's membership in an international organization, considerable financial responsibilities imposed on the state, and matters regulated by statute. And thirdly, there are there are also agreements whose ratification doesn't require consent granted by statute. And the fourth type of agreements are agreements that are not subject to ratification, and they are not a source of universally binding law. They are concluded by the Council of Ministers or by ministries. And now, let's take a look at the rank of international agreements and the hierarchy of the sources of universally binding law. So the Constitution doesn't explicitly determine the hierarchy of the specific sources of law, and we find out about it based on the provisions concerning constitutional review. They define the hierarchy based on the relation between the subject of review and the higher level norm for review. So agreements ratified upon prior consent granted by statute occupy the rank below the Constitution but above statutes. And this follows from Article 188 of the Constitution. Sorry. And agreements whose ratification doesn't require consent granted by statute have a rank below statutes but above regulations. Now, let's move on to discuss EU law and the Constitution. It should be noted that EU isn't explicitly mentioned in the Polish Constitution, and it's regarded as international law. So the Polish Constitution, as opposed to some constitutions of other countries, doesn't treat EU law as a separate system, but includes it within the constitutional term international law. And it doesn't matter that EU law constitutes a separate, closed, and autonomous regime of international law, which is stressed by a number of EU institutions. Relations between national law and EU law are first and foremost regulated by Article 9 of the Constitution, in accordance with which Poland abides by international law binding on it, which also refers to EU law. The next important provision in this context is Article 87, which, as a source of universally binding law, enumerates ratified international agreements. And EU primary law has the status or the rank of a ratified international agreement. What also refers to EU primary law is Article 91, which adopts the principle that ratified international agreements, upon their promulgation, constitute part of the Polish legal order and are directly applied. Norms envisaged in ratified international agreements become norms of domestic law, which have the character of universally binding law. In turn, paragraph 2 of this article concerns the primacy of ratified international agreements over statutes, if they cannot be reconciled, if an agreement can't be reconciled with a statute. So such agreements have the binding force lower than that of the Constitution, but higher than that of the statute. Also, paragraph 3 of this article refers to EU secondary legislation. And in accordance with this provision, law enacted by an international organization of which Poland is a member has the rank above statutes. So in the light of this provision, this law has primacy in the event of collisions with statutes. So this provision is applied in the event of conflicts or in the event of inconsistencies between a statute and EU secondary legislation. So in this case, authorities applying the law are obliged to disapply a regulation of national law, which is inconsistent with EU law, and are obliged to apply a norm of EU law. That is, they are obliged to determine the case based on an EU provision. Also, relations between the norms of EU law and norms of national law are regulated by the principle of the primacy of EU law. This is a conflict of law rule, which states that in the event of a collision between national law and EU law, a norm of EU law should be applied. But in accordance with the stance of the Court of Justice of the European Union, this rule excludes the application of national law that is inconsistent with EU law in a situation regulated by EU law. But upon Poland's accession to the EU, the most fundamental rule of the system of the sources of law hasn't changed, in accordance with which the Constitution remains the supreme law of Poland. So to conclude, it should be noted that EU law isn't explicitly regulated in the Polish Constitution, and provisions applying to international law also apply to EU law. And the primacy of EU law is recognized only over statutes and over the remaining sources of a lower rank, but not over the Constitution. There have been collisions between EU law and Polish law, which have been solved by the Constitutional Tribunal. So now let me briefly discuss the most groundbreaking judgments of the Polish Constitutional Tribunal concerning EU law. The Polish Constitutional Tribunal started to adjudicate on EU matters in 2005. And in the first period of adjudication on EU matters, which was mostly shaped by Poland's accession to the EU, the tribunal was concerned with developing a general framework of relations between EU law and national law, as well as the constitutional boundaries to EU law. In the light of this jurisprudence, the Constitution was perceived as the supreme source of law in Poland, dominating over EU law. Also, it mostly discussed general matters related to those relations, as well as the conformity to the constitution of EU treaties. So the first groundbreaking judgment discussing this issue was the judgment K18/04, and the legal provisions under review in this case embraced the treaty concerning Poland's accession to the European Union. The tribunal stated in this judgment that the Polish constitution is the supreme legal act with regard to the entire legal order that is binding in Poland. And in a situation where any provision of EU law were inconsistent with the Polish constitution, and it wouldn't be possible to eliminate this inconsistency by way of interpretation, even favorable to EU law, then the government would have three possibilities: to bring about changes in EU law, to amend the constitution, or to leave the EU. The next judgment, what was examined here was the conformity of the Treaty of Lisbon to the constitution. And the Polish tribunal discussed in it the issue of respect for constitutional identity and the ultra vires review of acts. In this judgment, it determined the boundaries of the conferral of competences on the EU, which may not have an in blanco character, although the boundaries of the conferral are not and may not be precise. Also, the following issues were discussed in detail. The principle of the primacy of EU law, the power of the Constitutional Court to declare the unconstitutionality of an EU legal enactment, the role of the Constitutional Court as a guardian of the state's constitutional identity, the boundaries of integration, and the EU remaining an association of sovereign states under the Treaty of Lisbon. And now the second period. The second period started in the year 2020. As of that year, the Constitutional Tribunal started to adjudicate on more specific conflicts between national and EU law, and they embraced the non-conformity to the Constitution of EU provisions, the non-conformity to the Constitution of EU law as interpreted by the Court of Justice of the European Union, the non-conformity of national provisions to EU law, as well as ultra vires acts of EU bodies. So this case concerned the imposition of interim measures on Poland by the Court of Justice of the European Union, whereas those measures referred to the justice system, which is the state's exclusive power. So in this judgment, the Constitutional Tribunal held that the provision of the Treaty on the Functioning of the European Union, which is inconsistent with the Constitution, is not embraced by the principle of the primacy and direct application. The Tribunal also clarified that this principle doesn't mean that the subject on which competences were conferred may independently extend them and create new ones by way of assumption. And the next case concerned the boundaries of the principle of primacy. What was reviewed here were norms pertaining to the organizational structure of Polish courts, which is a matter that is not subject to conferral. So this matter constitutes parts of Polish constitutional identity, and the fact that the Court of Justice derives the competences to control the functioning and organizational structure of the judicial system in an EU member state from Article 19 of the Treaty on the European Union constitutes an example of creating new competences on the part of the Court of Justice. Also, the Constitutional Tribunal discussed in this judgment the principle of the primacy of EU law, which, according to it, operates only within the framework of competences conferred upon the European Union. And the recognition of this principle over statutes and the Constitution outside this framework would mean the loss of sovereignty by Poland. This judgment concerned the constitutionality of a judgment delivered by the European Court of Human Rights. So the European Court of Human Rights recognized in its judgment the Constitutional Tribunal as a court determining individual disputes within the meaning of Article 6 of the Convention. But in accordance with the Polish Constitution, the Constitutional Tribunal is not such a court. It's only a court determining the conformity of provisions. So the Constitutional Tribunal stated that the judgment of the Court of Justice of the European Court of Human Rights is inconsistent with the constitutional provisions regulating the systemic position of the Polish Constitutional Tribunal. It was also noted in this... Okay, I'm just about finished. Okay, so in this judgment, it was noted that a norm created in the process of the application of law by an international body infringing the content of an international agreement or modifying this agreement without the state's consent and interfering with the constitutional order of the state is not subject to protection based on Article 9 of the Constitution. And such a norm is not classified as international law binding on Poland. Okay, so that would be the end of my presentation. Thank you for your attention, and feel free to ask me any questions after the panel or after my presentation. Thank you.